all discovery's been provided. I've also had ample opportunity to discuss this with my client. He is prepared today to enter a change of plea by way of information. He understands that by doing so, he will be waiving his right to have this case go to the Lake County Grand Jury, and no threats or promises have been made in order for him to do so, Your Honor.
All right, thank you. Mr. Davis, how old are you?
45.
How far did you go through school?
I graduated high school.
Are you a U.S. citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No.
Have you ever been diagnosed with or treated for any mental illness?
No.
Did you get a copy of this information?
Yes.
Do you have any questions about it?
No.
You understand you have a right to have your case presented to the grand jury for them to decide whether or not to indict you.
Yes.
Did you discuss that right with your attorney?
Yes.
Are you going to waive that right?
Yes.
Mr. Watson,
Thank you, Your Honor.
you should have it.
Oh, no.
Oh, no, here it is, here it is, here it is. Here it is.
So all this is you're waiving your right to have your case go to the grand jury. So I need you to sign right there for me.
Bob, you're going to need to grab a sentence date.
Will do.
All right, I'll accept the waiver of indictment. Now, before accepting your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you some questions. If you don't understand a question or you want more time to talk to Mr. Watson, let me know and I'll give you more time. Do you understand that?
Yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a lawyer, one will be provided at no cost. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of your rights?
No.
Do you still want to plead guilty to this charge?
Yes.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes.
You understand by pleading guilty to this felony that you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes.
Domestic violence is a felony of the 4th degree. It carries an 18-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
Yes.
Are you presently on post-release control?
No.
You understand your felony conviction prevents you from owning or possessing a firearm.
Yes.
Do you understand if a prison term is imposed in this case, you might have to serve a period of post-release control for up to 2 years under the parole authority?
Yes.
If you are placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes.
If that violation is a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes.
If that were to occur, the maximum prison sentence for that violation would be the greater of 12 months of the time left under post-release control. Do you understand that?
Yes.
Do you understand if a prison term is imposed, you are eligible for judicial release?
Yes.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 18 months. Do you understand that?
Yes.
Has anybody promised you I would be lenient on you just because you're pleading guilty?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
No. Yes.
Have you had enough time to talk to Mr. Watson before pleading guilty today?
Yes.
Has he discussed everything about your case and answered all of your questions?
Yeah. Yes.
Are you satisfied with the advice he's given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you knowingly and voluntarily entering your guilty plea?
Yes.
Do you have any questions?
No.
All right, Ms. Contour, if the case went to trial, what would the evidence show?
Thank you, Your Honor. If this matter would proceed to trial, the evidence would have shown that on April 24th of 2024 in Lake County, Ohio, the defendant did knowingly cause physical harm to Catherine Higgins, who at the time was living with him, as well as his sister-in-law. He has previously been convicted of domestic violence in the Willoughby Municipal Court, case number 20 CRB 979. That sentencing was dated September 1st, 2020.
All right, Mr. Watson, anything to add to those facts?
No, Your Honor.
Mr. Davis, did you hear what Ms. Contour said the facts would show if the case went to a trial?
Yes.
Are those facts true?
Yes.
All right, what is your plea to domestic violence, a felony of the 4th degree?
Guilty.
Mr. Watson? Bob, what do you got?
August 22nd at 9 a.m.
So this is what I just went over with, and the judge basically just went over with you. I need you to sign here, and then today's date is the 28th. So put 6/28 right here, put 6/28/24.
Mr. Davis, is this your signature on the written plea of guilty?
Yes.
Did you sign it voluntarily?
Yes.
And do you want me to accept your written plea of guilty?
Yes.
I'll accept the written plea of guilty. Defendant was present with Mr. Watson, advised of all of his rights. He's made a knowing, intelligent, and voluntary waiver of those rights. He understands the nature of the charge, consequences of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. Will accept his plea of guilty and find him guilty of domestic violence, a felony forum, and refer this for a pre-sentence report, a drug and alcohol evaluation, and a victim impact statement. Sentencing will be August 22 at 9 a.m. Mr. Watson?
Thank you, Your Honor. I please the court. My client has requested to address the court. I know we had some off-the-record discussions in chambers with regards to a possible a modification of his bond. Again, my client's asked to address the court, and then after he's done, Your Honor, I would just like to clarify a couple things that my client may say, but if the court would allow my client to speak.
Mr. Davis?
Stand up.
You can stay seated.
Okay. Your Honor, I went through surgery, and I was in the hospital for 7.5 months before this incident happened, and I got real sick, and I thought everything was healed in there, and when I went to jail, I got I'm sorry, I'm not really good with words. I'm like really don't really. the infection got worse and the bone died in there. And then they want to tell me they want to cut off my foot. And I found out that last Wednesday. I thought if it's possible to get an OR bond so I can go to the hospital from here. I have a social worker that goes through the jail. Her name is Bree, and she said that she would pick me up and take me to the hospital. And there's a doctor from Signature Health that would admit me in. And I don't want to lose my foot. And it's making me sick. It hurts all the time. The jail doesn't really know what to do with it. I don't know what to do, and I really just really want to get a second opinion. I really want to feel better, and I don't want to say too much more.
Your Honor, if I may, I know the court had some concerns about where my client may reside if the court were to consider modifying his bond. My client informed me that the same social worker had stated that there is a shelter.
Project Hope. She said, even if you get out of the hospital, she goes, we'll take care of you. We'll put you in Project Hope. She said, we will. I'll be here step by step with you, Anthony.
Now, Your Honor, if the court, I was unaware of social worker Bree with Signature Health. Social worker works for my office, Aaron Mayer, has been looking into some things for Mr. Davis. But that being said, if the court wants verification of anything, I can have Aaron from my office contact Bree from Signature Health, and I can certainly file a motion with the proper documentation to support it. But my client just informed me of that, just now, that he would have a place to reside. It would be a homeless shelter, but he would have a place to go. And Signature Health, the social worker with Signature Health, would be transporting Mr. Davis for his medical appointments if the court would consider addressing his bond.
All right, couple things. My concern about you being out there is you're going to immediately start drinking, number one.
Yep.
That, number two, that place is Miss Higgins in danger because she took quite a beating here. Okay, that's the second thing. Third thing is, I'm not sure Project Hope will take you because of the nature of the offense, okay? So I'm not doing anything right now. Mr. Watson, if you get me information, because I'm not going just on the words Mr. Davis tells me here today. So get me some plan that would work, and then I'll probably go along with it, okay? But it's just not, I'm just not gonna do it based on you telling me that this person says you can do this, and they're gonna do this, and the other thing, okay? I gotta have some solid basis for it.
Okay.
So the bond remains the same right now. Anything else, Ms. Contour?
Nothing further.
The sooner you get it to me, Mr. Watson, the sooner I can rule on it, because I don't want you losing your foot either. I want you getting to the doctor, which is why I had the sheriff take you to the doctor, okay?
I appreciate that too.
So the sooner the better. All right. Anything else, Mr. Watson?
No, Your Honor.
All right, we're adjourned.
Thank you, Your Honor.